What happens if you don't have an estate plan in place? If you don't have an estate plan, the state of Texas has one for you, and I promise you, you will not like it. In this video, I'm going to show you exactly what happens when you don't have an estate plan, who ends up in control, and why waiting to plan could cost your family everything. I'm attorney Aaron Miller, and about 15 years ago, I saw how tough it is for families when they lose control of their assets. So I dedicated my career to helping people plan and protect their future. If you'd like to speak with a trusted attorney, give us a call today at 214-292-4225 for a consultation. Many people assume their family will just handle things when they're gone, but what actually happens when you don't have an estate plan? The first thing is your family has to go through probate. Now, even if you have a will, probate is still required, but without any plan at all, probate can become a nightmare. Probate is a legal process whereby the court oversees the distributions of your assets. It's slow, it's expensive, and it's completely public. Everything you own becomes part of the public record, which means anyone, nosy neighbors, creditors, estranged relatives, can see exactly what you had and who's getting what. Here's what your family is dealing with. First, they have to hire an attorney, then they have to file paperwork with the court just to get started. And then they wait, and depending on how complicated your estate is, probate can take anywhere from several months to over a year, sometimes even longer if there are disputes or complications. While probate is necessary when there's no estate plan, it can be time-consuming and stressful. Your family will need to file paperwork with the court and wait for approval, which could often take a few months. Once the court issues letters testamentary, the executor can then access bank accounts, manage bills, and handle other assets, but there's still a waiting period that can be frustrating, especially during an already emotional time. Probate also comes with costs. Court fees, attorney fees, executor fees can quickly add up. In Texas, attorneys typically charge flat fees or hourly rates rather than a percentage of the estate. Even with the most efficient planning, these costs can take a bite out of your inheritance, and the process can be stressful for your loved ones. But the worst part, the emotional toll. The family is grieving. They're trying to plan a funeral, notify friends and relatives, and process a loss of someone they love deeply. And on top of all that, they're stuck dealing with a court system that moves at a snail's pace and treats them like a case number instead of a family in pain. All of this can be avoided with proper planning. A revocable living trust, for example, allows your assets to pass directly to your loved ones without ever going to court. It's private, it's fast, and it saves your family thousands of dollars and months of stress. Next, the state decides who gets your assets. When you don't have an estate plan, Texas intestate succession laws take over. That's a fancy way of saying the state decides who gets your stuff, and it can be complicated. For a married couple, some property goes to the surviving spouse and some to the children. The exact split depends on the type of property and if any of the decedent's children are from another relationship. If you're not married, your children inherit, and if you don't have children, it moves to other relatives. The point is this. Intestate succession laws are one size fits all. They don't account for blended families, strained relationships, or special circumstances. And without a plan, your assets may not go to the people you actually care about. Third, a judge picks who manages your estate. When you create a will, you get to choose who will serve as your executor or the person responsible for managing your estate, paying your debts, and distributing your assets. But if you don't have a will, the court appoints someone for you. Now, usually the court will appoint your spouse. If you don't have a spouse, it goes to your closest living relative. And here's the kicker. That person may not be someone you trust. It could be a family member who doesn't get along with the rest of the family, someone who's terrible with money, or someone who has their own agenda. Often it's just whoever steps up first. I've seen families torn apart because the wrong person was put in charge. Siblings who stop speaking to each other. Assets that get mismanaged or even stolen. All because there was no plan in place to name the right person for the job. Fourth, a judge could decide who raises your children. If you have minor children, this is where things get absolutely heartbreaking. Without an estate plan, you don't get to choose who raises your kids if something happens to you. A judge makes that decision. Now, you'd like to think the judge will pick the best person, someone who loves your kids and share your values, but judges don't know your family. They don't know that your sister is more nurturing than your brother, or that your best friend has been like a second parent to your kids their whole lives. Judges are just looking at paperwork and making a decision based on limited information. And if you have multiple family members who want custody, they could end up fighting each other in court for months or even years. Kids are stuck in the middle of a legal battle, being shuffled around, uncertain about where they'll end up. It's traumatic, it's expensive, and it's completely avoidable. All you have to do is name legal guardians in your estate plan. Yes, a judge still has to approve it, but when you've made your wishes clear in writing, you almost always honor your choice. It's one of the simplest but most important things you can do as a parent. And lastly, your family may need court permission to help you. Many people think estate planning is just about what happens after you die, but here's the truth. Planning for incapacity is just as important, if not more so. If you become incapacitated due to an accident, illness, or cognitive decline, and you don't have a plan in place, your family can't just step in and help you. They'll need to petition the court for a guardianship, which is a legal process that gives someone the authority to make decisions on your behalf. And let me tell you this, the process is brutal. It's expensive, time-consuming, and emotionally devastating. Your family has to prove to a judge that you're incapacitated, which often requires medical evaluations and testimony. It can take months to get approval, and during that time, no one can access your accounts, pay your bills, or make medical decisions for you. With a simple estate plan that includes a durable power of attorney and healthcare directive, you can avoid all this. You get to choose who makes decisions for you if you can't act, and they have immediate authority to act without needing court approval. The bottom line is, not having an estate plan doesn't mean things will just work themselves out. It means you're handing control over to the state and leaving your family to deal with the consequences. If you want to protect your family from probate, make sure your assets go to the right people and ensure your kids are cared for by someone you trust. You need an estate plan. And the sooner you do it, the better. If you're ready to take control and create a plan that reflects your wishes, give us a call today at 214-292-4225 for a consultation. We'll sit down with you, talk about your situation, and build a plan that gives you and your family peace of mind. And if you found this video helpful, don't forget to like and subscribe. We've got more answers coming your way. Click the next video right here to stay informed.